Hey everybody, this is my EDL 850 Module 13 presentation. I apologize, I cannot get Screencast-O-Matic to work, so I have to do that every time. So what is tort liability? So tort is a wrong that is committed by one person against another person. It's not necessarily criminal, a lot of times it's in a civil way, but it is a wrong nonetheless. And then liability is being responsible for something. So when you put it together, tort liability is when a person is held accountable for a wrong that they have committed against another person. Tort liability can be intentional or unintentional, so it can be something that you've done on purpose, not necessarily maliciously, but nonetheless on purpose. Or it can also be unintentional, which usually is like negligence, so something that you have almost not done that you should have. Usually these cases are in civil court, but like I said, they could be in criminal court as well. And then examples of tort liability that we see in schools would be assault or battery, so threatening to harm someone or harming someone. Defamation, so slander or libel that would cause harm to a reputation. Mental distress, so if that's any sort of emotional trauma that a student would be experiencing at school. False imprisonment would be holding the student at an inappropriate time, so you can't take lunch away from a student, you can't hold a student for a really long time after school. And then trespassing would be if the student had an improper search performed upon them or upon their property. I actually had a harder time finding court cases that involved tort than I thought I would. I thought I would just find mountains and mountains of cases, and I found some, but I really didn't find as many as I thought I would. I'm sure they're out there, but maybe a little bit difficult to find on the internet. So the first one that I found was Mitchell versus Cedar Rapids Community School District. This was decided by the Iowa Supreme Court in 2013. And in my picture, I have a student who's kind of hopping out the window while a teacher isn't looking. And in this case, the student didn't hop out the window, she walked out the door. But a 14-year-old student was, she skipped school, essentially. She cut class, I guess is what you would say. She left school early before her 6th period of the day, and she ended up hanging out with her boyfriend, and her boyfriend is 19, so their sexual relations would be considered sexual assault in this case. The school was found negligent because they failed to protect the student. In this case, they didn't have any measures in place that would keep the student at school or notify the parent that she had left school immediately. The parent wasn't notified that she had cut this class until later on in the evening. And then, obviously, that was too late to prevent this assault that occurred. So my reactionary measures are actually going to be pretty much the same for every single one of these cases, but my thought is always to start with an apology to the victim and family. Obviously, as teachers and as school officials, we'd never want things like this to happen to our students. We never want anything bad like this to happen. So just apologizing to the family and saying, I'm really sorry for what has gone on. How can we help in this case? And then assistance with the investigation. So the more honest and open a school is with the criminal investigation that would accompany this case, the better. And then creating future policy to ensure that this does not happen to any more students in the future. So proactive measures that could have solved this problem would be an increased security around the campus to make sure students aren't leaving, some sort of alarm trigger doors that alert someone when they're open so that students can't leave without someone being notified, and then better supervision of students. So in this case, the teachers didn't really act on the fact that the student wasn't in class, and a big part of this case was that the student was actually in special education and was determined to not necessarily understand the consequences of her own actions or the risk to her own safety, incapable of making decisions that would potentially put her safety at risk. She was determined to be incapable of evaluating that for herself. So how did this student get out of school with no one noticing if she was supposed to be accompanied by a parent or a teacher at all times? And then professional ethics. Really, in this case, we'd see a lack of concern for the student's welfare and a lack of student safety concern and a lack of protection of the student. So the student was supposed to be under pretty much constant supervision, and she was not at this time, and then no one really seemed to be concerned when all of a sudden she was missing. So clearly there was just a lack of professionalism in this case. Another case that I found was Johnson versus the School District of Millard. This was decided by the California Supreme Court in 1998, and in the picture you can see a couple students who look pretty banged up. They're still smiling, but they're banged up, and that's what happened to a first grade student in this case. Students were playing London Bridges, which is an activity where students kind of hold their arms out and sway each other around back and forth, and the student was actually ended up being thrown into a bookcase and obtaining a severe cut to his head. In this case, the music teacher was found to be negligent because she wasn't closely supervising the students during this activity. Her supervision, which was just not appropriate for the grade level and the activity that the students were partaking in. And the school district, again, had to pay some money in damages because of that. So reactionary measures here would be obtaining medical care for the child. So obviously we want to make sure that this child who's bleeding from the forehead is getting medical care. Apologizing to the victim and family. Again, an apology can never hurt. If the school's at wrong, it may not save a lawsuit, but you never know, it also could if the school says, we were wrong, we were sorry, how can we help? And then creating future policy to make sure this doesn't happen again. Proactive measures that could have been done before the incident occurred would be increasing the supervision of students. So if the music teacher had been paying more attention, had been assisting these students more, then this event likely would not have occurred. And then also maybe the music teacher didn't really receive proper instruction. Maybe she didn't know about negligence and tort liability and how she really needed to be supervising students. So educating our teachers in that can also be a really crucial step to preventing these sorts of things. And then as far as professional ethics go, again, this is a case where there needed to be more protection for the student and more concern for student welfare. And then also understanding the idea of foreseeability as a teacher. So this teacher could have foreseen that first grade students who are rowdy and immature likely would have struggled to partake in this activity without supervision. So she should have been supervising them more closely. I really wanted to find a Kansas case to use. So I found Glazer versus Emporia Unified, School District number 253. So this was decided by the Kansas Supreme Court in 2001. And in this case, a 7th grader was being chased by another student before school, and they ran off school property into the street, and they got hit by a car. And so the court ruled that the school did not actually have a duty to protect the student in this case because the student had not yet entered school in the morning. So I thought that was actually really interesting because the textbook talked so much about before school supervision of students, but in this case, it was actually found that the school was not responsible because the student wasn't in the building. So reactionary measures, again, we want to obtain medical care for the victim, apologize, even if it's not the school's fault. We still obviously don't want bad things to happen to our students, so we want to apologize to the student and family. I'm sorry that this happened to you. Assisting with the criminal investigation, again, I'm sure the police were definitely investigating this car collision, and then creation of future policy to prevent such cases from arising in the future. So proactive measures that could have prevented it in the first place would be better notification and communication to parents about how their students would be supervised before and after school. So if parents know if I drop my student off before 7:30 and they're outside, my student's not going to be supervised. That might discourage them from then dropping their student off before 7:30. Also, creating some sort of like fences around the roads or around the school building could also prevent the student from just running out into the street. And then professional ethics are kind of less of an issue in this case because the school district isn't at fault here. But, just being diligent about parent communication and preventing these things before they happen and being compassionate and honest with, the family and then being honest with investigators would all be ethical choices in this matter. So this case also deals with negligence, but in this case it's not a supervision negligence, it's actually a kind of a safety concern negligence. So this is Ludman versus Davenport Assumption High School. It was decided by the Iowa Supreme Court in 2017. So in this case, an 18-year-old student was struck by a baseball while he was standing in the dugout. He was on the baseball team, and this was a foul ball. He suffered pretty significant head injuries. He had a skull fracture and a brain hemorrhage, so definitely major issues. And then the school was initially found in trial court to be liable for this injury because they didn't do a better job of providing a safe dugout for students to be in. But the Iowa Supreme Court actually threw this case out last year because they determined that a trial judge didn't do an adequate job of letting the school district present evidence in their defense. So the school district wasn't allowed to show diagrams of the dugout, wasn't allowed to talk about the assumed risk of playing baseball or anything like that. So this case actually is going to go through a retrial, which has not happened yet. So currently this case is undecided. I can kind of see this case going either way. Schools definitely have a duty to protect their students, so they should be protecting them in the dugout. However, there is also an assumed risk, especially for an 18-year-old student. This is a student who's mature and capable of making their own decisions, so there's some level of assumed risk, and they should be paying more attention to the baseball game in order to prevent themselves from getting harmed as well. Reactionary measures, again, we want to obtain medical attention and apologize to our family. and then create measures, create policy that could improve safety in the future. And then also I was thinking that even if the school district thinks, we're not liable for this, they may want to consider adding in some safety measures to their baseball field just to prevent future incidences from occurring. And then proactive measures, increase safety measures again. So if they had netting or fencing or something in front of the dugout, that may have increased the player's safety. And then also, if we talk to our baseball players about, hey, when you're playing baseball, this is what you need to be paying attention to. This is what you need to be looking out for. And we talk to all of our various athletes and club members about the assumed risk of the activities that they're partaking in. Sometimes we can help them increase their own safety. And then professional ethics, like I said, increased concern for the students' education in this fact. So how are we educating our students on the risks that they're assuming while they're participating in football or cheerleading or baseball or any other activity? I really was struggling to find cases that weren't about negligence. So this was the only one that I really found that wasn't strictly a negligence case. So in this case, it was Johnson versus Perry, and this was in the Second Circuit Court of Appeals. So a parent, Johnson, was banned from attending all school events by the principal, Perry, because of a disagreement over the plaintiff's daughter playing basketball or not playing basketball. The parent felt that this was an unfair punishment. They claimed emotional distress, isolation from other parents, embarrassment, things like that. So the court has ruled that the principal was not allowed to ban the parent from all events. So public events like a basketball game, you can't ban a parent from because it is a public event. However, part of the decision was actually overturned by the Court of Appeals here because they did say that the principal was allowed to ban the parent from certain private school activities. So activities where the entire public is not usually invited. So reactionary measures, in general, this case had a lot of meetings and emails and letters and calling the student into the principal's office, and it just seemed like a very big fight kind of between all different parties, and everybody was seeming kind of vindictive towards one another. So I think that a good old-fashioned apology could have really avoided a lot of harm in this case. So if the principal said, I'm sorry for this, moving forward, let's just go forward professionally, I think probably we could have saved a lot of trouble in this case. And then creating future policy about where parents are allowed to be at events, when they're not allowed to be at events, etc. And then, like I said, mediating this conflict before it escalates to the point of needing to go to civil court. Proactive measures, again, I said mediation. That is really the solution in this case. And then policy on the different events. And then professional ethics, like I said, this case has a shocking lack of professionalism on all parties involved. So as a principal or as a teacher or as a coach, you need to be able to say, regardless of my past disagreements with you or with your student, we need to be able to move forward in a peaceful and professional way. And so we need to kind of have a fresh start from here on out. So not being vindictive would really help here. This is my works cited page, so the different sources that I used. It's primarily court cases and then the textbook that we used for the class. Thank you for watching my presentation. I hope that you've enjoyed it.